Order, order. This is a meeting of the Northern Ireland Affairs Select Committee. I'm delighted today that we are turning our attention to a one-off session examining the potential implications of Northern Ireland should the United Kingdom withdraw from the European Convention on Human Rights. And I'm very pleased to be joined by an expert panel. We have, from left to right, we have Stephanie Needleman, who's Legal Director of Justice. I'm grateful to you, Stephanie. I should declare an interest that I'm a council member of that organisation. Then from the left, Professor Christopher McCrudden, who's Professor of Human Rights and Equality Law at Queen's University, Belfast. Welcome, Professor. Then we have Alyson Kilpatrick, who is Chief Commissioner of the Northern Ireland Human Rights Commission. Welcome, Commissioner. And then finally, Dr. Colin Caughey, who's Director of Policy at the Northern Ireland Human Rights Commission. Welcome, one and all. And I wanted to open the batting, as it were, with a general question, first of all, about the practice, how the European Convention is applied in practice, and a discussion about the concerns that we hear about it, and frankly offering an opinion as to whether those concerns are actually valid. And I wonder if I'll start with Professor McCrudden.
Thank you, Chair, and thank you for the invitation to attend. It's a real pleasure to be here. I mean, maybe one of the ways of starting is to think about what popular opinion says about the Convention. And there has been some polling done in September 2023. So the question that was put by the Savanta poll organisation, so a reputable polling organisation, as to whether the UK should stay part of the ECHR or withdraw from it. In Northern Ireland terms, 68% of respondents said stay.
Yes.
And 18% of respondents said don't know. 14% of respondents said withdraw. So, people around the table here know better how to interpret polling
Yes.
than I do, but nevertheless, it is an indicator of quite an interesting lack of evidence as to why, as to there being popular opinion in Northern Ireland urging withdrawal. So that's the first point. In terms of the arguments that have sometimes been put about concerns, I suppose there are three or four perhaps. One is that the courts have gone rogue and have interpreted the Convention beyond what is appropriate. And to be honest, myself and my colleagues at Queen's have done quite a lot of work on this,
yes.
and we see no evidence that the courts have gone rogue. The second is that in some way it's inappropriate for a foreign court, as it's sometimes called, to adjudicate these issues, and that is in some way doing down parliamentary sovereignty.
Yes.
And of course there are two obvious points to that. One is that it's an exercise of parliamentary sovereignty to accept the Convention and to incorporate it in the Human Rights Act. But more importantly, that if we are, as the Prime Minister often says, anxious to remain part of the international rules order, international rules need to be interpreted, they need to be applied, and they need to be enforced, particularly in circumstances where there is either controversy or lack of trust. So the question, I think, then is how would you envisage an international organisation that did not have a mechanism for enforcement and interpretation? So those are two common approaches. I suppose the third is that in Northern Ireland terms, there is sometimes criticism the other way, that the European Convention doesn't go far enough. And that therefore leads into questions about social rights and economic and social rights. And that leads us into the question of the Bill of Rights, but perhaps that'll come up later on. If there are other concerns that you want to put, Chair, I'd be happy to address them.
Thank you very much, Professor. That's a very good opener. I wonder if I could go to Alyson Kilpatrick next.
I'll come on to practice, because I think that's a really good example, a working example of why the Convention has been a very good thing. But just to deal with, to add to what Professor McCrudden has said in relation to the concerns, and they're often summed up as, I think, it's a foreign court, foreign decisions imposed on us, particularly in relation to interim measures recently, those who talked about a lot, and also that it's overreaching, and Professor McCrudden has touched on that as well. Well, in terms of foreign court, it's not a foreign court, we're on the court. We nominate our judge to the court and always have, and we vote for the other judges as well. So it's very far from being a foreign court. It's deciding on things that we have put before it. We as a sovereign nation have put before it democratically. And it appreciates subsidiarity and the margin of appreciation. So that's built into everything the European Court does. Interim measures, perfectly common measure that most courts have to prevent irreparable harm. They're used not commonly at all. I think only one last year used against the UK. So it's a perfectly ordinary way of court protecting its business and protecting a person in the meantime while the decision is being made. And it really is exceptional circumstances. For example, somebody may die if deported. That's often the sort of situation they're talking about. In terms of overreach, while I can understand, I think I have more sympathy for that concern because I can see where it comes from. And I can see that people are saying, we never thought about climate change, for example, one of the cases that they're concerned about. They never thought about that back in the 50s. Well, no, they didn't. But what they did was come up with a framework of principles that could adapt to changing times and changing circumstances, and has to have done the same way our common law is adapted and changed to changing times. So new challenges arise, and the convention is sufficiently broad that it can adapt to that. So they're not creating new rights, they're simply using the framework in new circumstances. So it's the same rights, but new circumstances. But talking about practice, Northern Ireland is a really good example, I think, of it working in practice. And it is applied in everything, sometimes not even with people knowing it. So the duty on public authorities to act compatibly has really gone through the civil service, has gone through all public bodies, policing, criminal justice, medicine, social care, caring for older people. And they've had 25 years of this now. They've been trained very well. It's second nature. And it works really well. And it gives people a remedy, it makes them feel important, and it makes people who are normally in a minority group feel important, people who maybe don't have anywhere else to turn. And that's very much also part of our common law, but the common law has not traditionally provided remedies for those minority groups or the vulnerable. But if I could take something that I have a particular experience of, and that's policing. I had the great privilege of being a human rights advisor to the policing board in Northern Ireland from about 2009. I've seen through my time now 6 chief constables. And they were at the forefront of Human Rights Act and its application to the most contentious situations and the most difficult circumstances. And in those areas where most people would say, oh, come on now, you can't be asking them to concern themselves about this, they've got more important things, it's dangerous, etc., etc. The police took to it after a little bit of initial scepticism and fear. They took to it just in a remarkable way. And every single one of those chief constables, particularly now the most recent, has endorsed the human rights approach to policing, not just as a nice thing or not just as an aspiration, but why operationally it works. And what they have all said to me is it makes decision making easier. It's much easier to send out a newly trained constable or my chief superintendent and know they're equipped to handle whatever may be thrown at them, because it's this decision making model. And I've seen them when nobody else can see them. I've been in operational rooms, settings, observing. And it's the most natural thing in the world. I spoke to one recently retired. I said, what would happen if you didn't have the Human Rights Act anymore, you didn't have the convention to set your standards? He said, I don't know what we'd do. Because some of us, it's all we know. We've been here for 25 years and it's all we know. You know, so, and it, as I say, it works beautifully for everything from recruitment right through to stop and search, right through to what do you do with a mentally ill person on the edge of a bridge. You know, it really does help with all those decisions. Housing is another one I have quite a lot of direct experience with. And what the Human Rights Act, incorporating the Convention, did immediately was to allow courts, just local courts, magistrates' courts, county courts, to look at the fairness and the reasonableness and the circumstance of the person in front of them, to make sure that the decision they were making was fair and proportionate. That's all it did. It didn't constrain anything, didn't stop them making decisions according to the law. And that made a huge difference. So lots of people who would have been evicted perhaps, but could have remained in their property with just a little bit of help, courts were allowed to, as a result of the Human Rights Act, suspend and give them opportunities. And this is coming up again now in relation to no-fault evictions. And so this is a debate which progress is made and then it stalls because of sometimes myths and rumours and gossip about what it causes in a practical sense. But in my experience, it's only been positive.
Yeah. And it's right to say, isn't it, that a lot of commentators here tend to look at it from an England and Wales perspective, separate jurisdiction, with a whole panoply of different rules and laws, like the Police and Criminal Evidence Act of 84, for example, 40 years old this year. And Northern Ireland is a separate jurisdiction with its own legal history, which means that the context is entirely different.
It is. It's similar, but it's very different in very material ways. So we've had police and criminal evidence order pre-Human Rights Act. We've had various criminal justice rules and procedures, etc. But what made a difference, I think, was requiring every single public body to match the same standards. And I think in terms of policing, why it worked so well is the policing board, the police had a statutory duty to comply with the Human Rights Act. And it was part of the Code of Ethics as well. So it was made immediately operational and practical. And the reason human rights were so integral to the peace agreement and to Northern Ireland being able to move, in my view, move on, was that it was something that the government of the day couldn't affect. There are these standards set and agreed across 47 nations then. And it was something that nobody could take away from them. And that was really important at the time because there was distrust in both. There's more than two communities in Northern Ireland, but between the two main communities there was distrust. And what they said was, we're going to leave it to other people who've agreed these standards, and you're all going to benefit from it. And the minute a minority group doesn't benefit from them, then we know that everybody is going to be at risk. And that was why the European Convention and Human Rights Act and the Belfast Good Friday Agreement made such a difference.
Yeah, and I think we'll come back to that in the discussion as to the particular context and why it was so important in 1998. Dr. Caughey, do you want to come in?
Just really to highlight where there have been concerns in relation to overreach, the Council of Europe and the European Court of Human Rights has been very responsive to these concerns, emphasising its subsidiary role. The Court's emphasised that judicial intervention cannot replace or provide any substitute for the action which must be taken by the legislative and executive branches of government.
Yeah, the subsidiarity point, which is of course part of the reforms that were obtained, and we'll come back to that question of reform in a moment. I want Stephanie Needleman to come in.
I'm not sure there's that much to add, but perhaps just to pick up on a couple of points that have already been made. I think one of the key criticisms is around this idea of the convention being a living instrument, and as others said, we want treaties to be read in a way that reflects changes in society. The living instrument doctrine has led to the recognition of rights that we would see as absolutely incontrovertible these days, like the fact that children born out of wedlock shouldn't be treated differently to children born to married partners. The definition of family includes same-sex couples. It also, as Alyson said, enables the court to consider the human rights implications of technologies and sciences and things that perhaps didn't exist at the time that the convention was drafted. It's been able to consider the changes that have been affected by the rise of the internet, mass surveillance, the interception of communication, and things like surrogacy as well, which were clearly not in the mind when the convention was first drafted. I also just wanted to pick up on the international reputation point as well. I mean, leaving the convention would have a serious detrimental impact on the UK's international reputation. We would be in the company of Russia and Belarus as the only states in Europe not party to the convention and part of the Council of Europe. And it would hugely weaken the UK's voice and influence abroad if we were no longer part of the European rules-based order. And I just wanted to add that obviously business and investors as well, they rely on a stable human rights framework and the certainty that comes around that. And as I'm sure we'll go on to discuss, withdrawing from the ECHR will create significant amount of uncertainty in Northern Ireland, but also how it impacts Westminster legislation and government as it applies in Northern Ireland as well.
Well, thank you. That really leads on neatly to the next question I wanted to ask you, which is, is reform from within possible? In fact, there are examples where it already has been done, most recently on the interim orders, Rule 39. Or is that a pipe dream, and is withdrawal, for those who don't like the regime and criticise it, is withdrawal really the only viable option? Because increasingly that's the language that we're hearing in the debate. I can remember the prisoner voting argument 10 years ago. Nobody was talking about withdrawal. They were talking about how we accommodate that judgment. A lot of us, me included, thought it was not a very good judgment. It wasn't. But it was negotiated in the Ministerial Council of the Council of Europe in a way that everybody was satisfied with, albeit it took a long time. But it was interesting then that withdrawal wasn't a serious option, whereas now it seems to be on the table in a way that it wasn't a few years ago. Perhaps, Professor McCrudden, if I start with you, as to whether you think reform is possible, or whether the logic is, to adopt Jonathan Sumption's view, withdrawal.
So, I think there are maybe 2 points to make on this. The first is that past experience shows that reform has taken place. Whether it be in terms of actual amendment of the convention itself, and there's been mention of subsidiarity. Subsidiarity was an example of exactly when the convention was amended. And of course there's the opportunity for new protocols to amend, and that has been a fairly frequent occasion. So past experience says there is obviously the opportunity to amend. And in that respect, the 10 years or so of negotiations that the UK government led in the past on reforms to the convention were not wholly successful, but they certainly were not unsuccessful.
Yes.
So that's the first point. And another example of that is, as you mentioned, Chair, in the context of the application of the convention by the Committee of Ministers, obviously there is opportunity there for negotiation. The second point I'd make is this, I think. Of course there's an opportunity for a negotiation and reform. But in part it depends on what the attitude is going into the negotiation. And sometimes there's been the suggestion that, well, we have to go into negotiation, but basically it's in order to show that the convention can't be amended and can't work. And that seems to me to be a suggestion to negotiate in bad faith. And past experience, I think, indicates also that there is a degree of favourable response and serious engagement when the member state has concerns and wants to negotiate them, but not if they're done in bad faith. So in other words, if the negotiations for reform are essentially conducted in order to show how awful the convention is, and as a prelude to, and indeed an occasion for withdrawal, then that's not going to go down well. And it's likely to be seen as operating in bad faith. And of course, we've been in this position before in terms of prior to the Brexit situation, where there was an attempt at negotiation which didn't work, and then that led to withdrawal. So there's a danger here that you get into a position where withdrawal, as it were, is the only option because you're making impossibilist demands, or you're negotiating in bad faith.
Alyson, Kilpatrick.
Yes, you've already alluded to the fact that reform has taken place, and very recently, Brighton Declaration, Copenhagen Declaration, all of these things changed as a result largely of the UK making representations. Protocol 15, which has taken up a lot of the concern and has expressly referenced subsidiarity, margin appreciation, etc. Reform of Rule 39, as you say, that's taken on concerns, change in the time limit. But the case you talk about, the prisoner voting, the Hurst case, that's a really good example as well of when the court can actually be very reasonable and can compromise. They reached a compromise and they accepted, I think it was on temporary licence, wasn't it? The prisoners who were on temporary licence.
Postal votes were available to certain limited classes.
Yeah. So it was less than what the court initially had. Yeah, but they reached a compromise. They were sensible. So it worked in that case. A lot of the, I think, how I would categorise some of it, and I hope I'm not being too unfair, is the suggestion of leaving tends to come immediately after a decision is made that is uncomfortable, or even could be wrong, but our own courts make decisions that could be wrong, they're overturned. And I'm sure the Supreme Court, our own Supreme Court, has made decisions with which not everybody is happy. But you don't leave these structures. And if you leave these structures, where do you go? Where does the individual citizen go? And it's all very well saying that the UK courts are great, and they are. I practiced in them for years. I have huge respect for them. But the right of individual petition to Strasbourg remains really important, not just symbolically, but practically as well. And we have gained a lot of things that most of the people who complain about the convention would not dispute by going to Strasbourg, not in our own common law jurisdiction. And it's often the people who need the help the most, like victims of crime. So I hear lots of things. I still hear them despite all the defences we put up. So for some reason, we're not addressing concerns sufficiently. But I do feel sometimes that people aren't listening to the defence. And there are just knee-jerk reactions to things. But I would ask, well, what do you have instead? Do you go into the company of Russia and Belarus? And what do you say to your citizens?
Yeah, well, we can come on and discuss what a domestic Bill of Rights might look like. But I wonder, Dr. Caughey, do you have any further observations on reform versus withdrawal?
I would just highlight the effectiveness of the government in its engagement with the Europe and the other international human rights mechanisms throughout the world that the UK contributes to very successfully, and the importance of the UK's reputation as a country that upholds and supports international human rights processes, whether that be the UN Human Rights Council or the different UN treaty bodies that the UK has a reputation of providing membership towards, is very important, and that has led to the UK's reputation as a nation that stands for human rights and has assisted it in supporting Council of Europe and other institutions to develop and grow, ensure they're protecting the rights of all.
Thank you. Stephanie Needleman.
Yes, as the others have said, there's obviously is the opportunity for reform. Just to pick up on the Rule 39 changes that we've recently seen, I mean, they explicitly addressed a number of the concerns that the government had in relation to their use when it came to Rwanda. Yes. Specifically, the governments to which they're addressed are now able to ask court to reconsider the Rule 39 ruling if they consider the measures are no longer necessary or where they possess information which was not in front of the judge when the Rule 39 measure was used. I also want to flag another method by which we can influence the Strasbourg Court is obviously through judicial dialogue, and there has been a long history of judicial dialogue between the domestic courts and Strasbourg, and we've seen in a number of cases Strasbourg essentially changing their view in relation after domestic courts have sort of set out the domestic position in the UK. I mean, ultimately, I think it's a question of whether people... The Convention sets a floor for rights protections across Europe, and ultimately it's a question of whether those who want to leave the ECHR want the UK to be part of that or not. I mean, I think if they don't, then reforms that we're talking about aren't going to have much impact. But for people somewhere in the middle, there are obvious ways in which we can reform from within if that is felt it's necessary.
And there are good examples, aren't there, of that dialogue having produced results. The whole life order murder sentencing case where the UK was able to demonstrate that whole life orders were perfectly compatible with the Convention. Reverse burdens of proof in things like confiscation of proceeds of crime. All these have found to be compatible, even though they're pretty draconian and strong criminal justice measures. They've all been found to be compatible with the Convention.
Yeah, court-martial procedures, political advertising, so...
Exactly. And just for the record, in 2023 saw the United Kingdom in breach of the Convention on one occasion. In 2022 we were in breach on 2 occasions. Russia in its last year of membership was in breach, I think, on 324 occasions.
Oh dear.
Yes. Jim Shannon.
Jim, thank you. Ladies and gentlemen, real pleasure to see you. Thanks for coming. If you don't mind, a special welcome to Dr. Caughey. We've known each other for a long time. He comes from outside Ballyhalbert originally, so very farmers as well. So a good stock there, you know. Just to say, I've 3 questions. I'll pose the 3 questions, Mr. Chairman, and let whoever wishes to respond to them.
you, Jim.
The first one is a follow-on from the chairs. It's about the government's intention to withdraw from the ECHR. Can the Sewell Convention act as a barrier for that to happen? Specifically, what would be the issues in relation to the convention rights for the settlement, devolution settlement for Northern Ireland? And lastly, in relation to that one, the ECHR require amendments to the Devolution Acts, which could mean the Northern Ireland Act. So that's a question to follow on from the chair. The second question I have is one that concerns me greatly, and it's to do with freedom of religious belief. I chair the APPG here for freedom of religious belief. So I speak up for those with Christian faith, those with other faith, and those with no faith. We've had a tradition, as all four of you will know, in Northern Ireland of open-air preaching. I can never remember my mum and dad did it when we were wee boys in Ballywalter and the Ards Peninsula, and it was all across the whole of Northern Ireland. There's some concern that may be legislated against, and I would have concerns where that freedom to preach the gospel may in some way be inhibited. And my third question, Mr. Chairman, just to put them all on record if I can, is in relation to the legacy issues. I've fought consistently, and indeed we have all fought consistently on that issue of the legacy issues. I think of the people we've met, and you, Mr. Chairman, had met some of them last week. We spoke about the Kingsmill massacre in an adjournment debate there Thursday week ago in the House. Families seek justice. I think of Raymond McCrudden from North Belfast, who seeks justice for his son, his 20-year-old son, who was brutally beaten to death because he had the courage to stand up against UVF terrorists and scum that they are. I'm also very aware that some of my constituents have never had justice. For instance, I think of the Ballydugan Four, who were murdered by the IRA, and only one person was ever made accountable on a small charge, but those who were intricately involved in their murders have never, ever been made accountable. So when it comes to legacy issues, for all of us on both sides of the community, for my family personally, for my friendships with the four UDR men, for my cousin Kenneth, who was murdered on the 10th of December 1971, the three people who killed him fled across the border to sanctuary. The Kingsmill massacre guys, they also fled across the IRA men who killed them, the three of them, fled across the border. And the Garda Síochána didn't divulge all of the evidence that they had. So those are the issues and those are the questions on the ECHR withdrawal that government wants to do, on the issue of freedom of religious belief, and thirdly on legacy issues. And I'll leave those questions, whoever would wish to come back in there, if that's helpful.
Thank you very much indeed there, Jim. Three distinct parts, but I'm happy for each witness to answer them in the round. Professor McCrudden?
Thank you, and it's a pleasure to see Mr. Shannon. I had the pleasure of showing some guests around his beautiful constituency over the weekend. So it's a pleasure to see you. So on Sewell, so I suppose the first issue is why Sewell might arise, and the question there, I think, is whether if the UK were to withdraw from the convention, whether that would require an amendment of the Northern Ireland Act. And at the moment, the Northern Ireland Act, in several sections, as you well know, provides for limits on both the Assembly and the Executive, which cannot act contrary to the ECHR. So if the UK were to withdraw, then one would assume that they would have to amend the Northern Ireland Act. Yes. That would then extend the jurisdiction of the Northern Ireland Executive and Northern Ireland Assembly, and therefore that gets you into issues of the expansion of the devolved settlement. And therefore it's legislating in the area of the devolved settlement, which then triggers Sewell. So the first point, I think, is that Sewell could arise. The second part of that, however, is that in arising, the issue is whether the UK government or Parliament would pay any attention to it, even if the Northern Ireland Assembly did not pass a Sewell acceptance recommendation. And in the recent past, clearly the Sewell has been overridden in certain contexts. So the issue then arises as to whether Sewell is enforceable, and it's clear from the Supreme Court judgment in the first Miller case that the Sewell Convention is not enforceable in law. So all in all, my view is that Sewell could be engaged, but that it's likely to prove a very weak reed in preventing withdrawal.
Yes, you're right, because the Scotland Act, it was declared, it was a declaratory clause, wasn't it? A declaratory section, which was referred to in Miller. So it has no practical effect. It's a bit of declaratory legislation.
In the courts.
Yes.
And of course you'll know this better than I, even when it was legislated in the Welsh legislation,
yes,
it was still not regarded as justiciable. And so my first response with regard to Sewell is that it would be a weak reed. With regard to more generally to your question, Mr. Shannon, on the effect on the devolution settlement, it clearly would be of very considerable importance. Leave aside the question of the Good Friday Agreement, which perhaps we'll come to, but in terms of the Northern Ireland Act at the moment, there is, of course, the provisions that we've just mentioned with regard to the ECHR. And so the Northern Ireland Act would have to be amended if the UK was to withdraw. It would be a very strange situation for Northern Ireland institutions to be required to comply with the ECHR under the Northern Ireland Act while the rest of the UK was not a member of the ECHR. I can't really envisage that.
It's right, isn't it, that human rights issues are not devolved to Northern Ireland. They are still within the purview of the UK government, aren't they? There's that.
Well, yes and no. I mean, in terms, for example, of the implementation of some human rights standards, for example, those that arose from the EU, then the institutions have responsibilities there. But of course, the point is well made that the Northern Ireland institutions, the Assembly, cannot legislate beyond devolved matters with regard to human rights. And in that sense, the Scottish decision in the Supreme Court would apply, which disabled, was interpreted as not allowing the Scottish Parliament to legislate in non-devolved areas. So it would have a significant effect in terms of the current devolution settlement. And that's before we get to the issue of the Good Friday Agreement.
Thank you. Alyson.
Christopher McCrudden is the expert, so I'm not going to add anything in relation to that, if that's okay. I can't possibly add anything of help. I would like to take just briefly the other two, if I may.
Yes.
And actually, they're two really good examples because both are protected under the ECHR through the Human Rights Act in a way that the Commonwealth simply would not protect them at all. So those both rights, the right to, if I take legacy first, the right to be warned of a risk, the right to an effective investigation, the right to information, to participation in the investigation, the right to have perpetrators prosecuted. All of that comes from the European Convention, not from any domestic law. Similarly with religious belief, that's found in the Convention, and that's what would protect people wanting to express their faith on the streets. The Commission has always taken the view that you do not ban religious expression in public, that would be contrary to the ECHR. But what you are entitled to do is balance the rights of everybody in the vicinity. So there are certain things you don't have a right to do. And I know this debate comes up in relation to the use of things like megaphones and banners, etc. All of that it's very nuanced. It's not easy. There's no one answer for that. But if you think about it in terms of safe access zones around clinics, health clinics, and it's often reported as being a ban on prayer. It's not. It's a ban on activity within a zone, but you can certainly pray outside of the zone. So it's attempting to reach a balance between those accessing the clinic and those who want to protest against the clinic being there, or even offer prayer to people attending the clinic. So it's always about balance, and it's very difficult to give you can't really give a single answer to that. But what I would say is, if you look at the jurisprudence of the ECHR, applied by our domestic courts, you will find the balance in there, and I think that's what protects both. It will protect those who want to express their faith in public, and I know for a lot of people that is very much part of their faith, is sharing it with other people, and that would be protected within limits.
And in prayer?
Well, again, it depends on the context. No, I don't think anybody would say that you have to be silent if you're outside the City Hall, for example. I don't think anyone has suggested that, and if they did, I think we would probably object to that on behalf of the people who wanted to express their faith outside the City Hall. But it's how you express the faith, what you say in the course of expressing the faith, and in the context. So if for example, well, I could come up with a lot of examples, might be unhelpful, but it is about context as well. And I haven't yet met anybody, I have to say, who wants to share their faith with others, who goes out to offend or frighten or intimidate anybody. Right. But there have been situations where that has happened. So that does need to be controlled, but it doesn't mean shutting people up and stopping them from expressing their faith.
Before Alyson goes on to the question of legacy, may I just add a footnote to the question, which is, I think, a very important one. The first point is that sometimes, particularly in Northern Ireland, rights are seen as weaponised by one side rather than another. And I think it's important to address that issue head on. And your question sort of touches on that to some degree. That is, are religious believers protected in the same way that non-religious believers are protected? And I'll mention 2 points that are relevant, I think. One is that, I had the honour of representing Ashers in the Ashers case. Mm-hmm. And the effect of Ashers was to strongly uphold rights to freedom of religion and freedom of expression, using the European Convention on Human Rights, in part. And so it's important, I think, to put that on the record, because it was an extremely controversial and important case where freedom of religion was upheld. The second point that's relevant, I think, here is that we'll talk about the Good Friday Agreement, and I'm sure later on, but you will know that one of the provisions that's specifically mentioned in the list of rights protected by the Good Friday Agreement is freedom of religious belief. We now have the situation, of course, that Article 2 of the Protocol upholds those rights. And so we have the position, therefore, following the Windsor Framework Amendment and Agreement, that the Windsor Framework will specifically be used to uphold freedom of religious belief under the Good Friday Agreement. And again, I think it's worth putting that on the record, because sometimes those who oppose aspects of the Windsor Framework might not be aware of the extent to which freedom of religious belief is specifically protected by virtue of the Windsor Framework, in addition to the European Convention on Human Rights.
Yes.
Very briefly on legacy, because I've sort of touched on this already, but the Commission was probably very early doors a critic of its compatibility, the Act's compatibility with the European Convention, for all the reasons you say, and also the impact on people in Northern Ireland, victims across Northern Ireland. We have intervened in a challenge to the Act, which is now to be heard in the Court of Appeal in June. So we've put those arguments to the Court of Appeal. The advice we gave to government was ignored at an early stage and throughout. So the only recourse we had in the end was to participate in legal proceedings, which is what we're doing. But I think the view of people in Northern Ireland hasn't changed, and it mirrors very much what you've said, for the reasons you've said them. I don't know if Colin wants to. Colin's been quite active in preparing our submissions on legacy.
Thank you. Just to highlight, the withdrawal from the European Convention on Human Rights would have significant negative impacts on the UK human rights framework and on the devolution settlement for Northern Ireland. The European Convention on Human Rights is the fundamental building block of the UK's unwritten constitution. And in the context of Northern Ireland, I don't think we can underestimate the significance of Section 6 of the Human Rights Act that makes it unlawful for a public authority to act in a way that is incompatible with a person's rights under the ECHR. This provides reassurance for all within Northern Ireland and for all within the UK that when you're interacting with a public authority and with public officials, that those officials are bound to respect their human rights and to exercise the powers that they hold over people in a way that respects the human rights of those individuals. So that applies to those councils that you refer to who are enacting bylaws, and it applies to those who are looking at legacy cases. It applies across the board. I think the importance of that in the Northern Ireland context, where we need to build up trust in our public officials and our public institutions, really can't be underestimated. I think it underscores, as Chris highlighted, the support that there is for the European Convention on Human Rights in Northern Ireland and the valuable role that human rights plays in supporting peace and sustained society in Northern Ireland.
May I just add a footnote to that as well,
yes,
if I may? First of all, I should say I'm currently representing the Equality Commission for Northern Ireland, and therefore I need to declare an interest at this point in terms of the Dillon case, the legacy case.
Yeah.
So I won't touch on that. But more generally, Ms. Shannon's point about those who left Northern Ireland having committed murders and went to the Republic. Of course, you will know better than I that one of the major controversies was extradition. And the difficulties in the early days of extraditing people from the Irish Republic into Northern Ireland. I have to say that one of the reasons why that became a lot easier was because of the European arrest warrant and equivalent arrangements. I should also say that if the UK were to withdraw from the European Convention on Human Rights, those extradition arrangements would be a lot more difficult because you would be extraditing from an ECHR and EU country into a country that was neither EU nor ECHR. And the extradition in those circumstances is extremely problematic.
Yes, definitely.
Yeah, just to add a couple of points. Professor McCrudden mentioned that the Northern Ireland Act would need changing if the UK were to withdraw from the ECHR, and that's how you get to the point about the Seoul Convention.
Yes.
But I think taking a step back, there's also a question about whether withdrawal itself from the European Convention could be done by the exercise of royal prerogative, or in and of itself would need some legislation in order to be able to do that post-Miller 1. There are some sort of obvious differences because of its impact on the Human Rights Act, I should clarify. There are some obvious differences between the Human Rights Act and the European Communities Act, but there's definitely a live question as to whether legislation would be needed to withdraw from the ECHR at all before you even get to the point of amending the Northern Ireland Act. In relation to the amendments of the Northern Ireland Act, I guess you could have a situation in which you don't amend the Northern Ireland Act and retain the references to the ECHR in there. But as Professor McCrudden said, it would be a very sort of odd situation to have a devolution settlement based on a treaty to which the UK isn't party to. In addition, it would lead to a bifurcation of rights protection between Northern Ireland and the rest of the UK. Definitely for devolved matters it would mean different standards, but there's also a complication about what would happen for reserved or accepted matters and their application within the jurisdiction of Northern Ireland. So would the Home Office have to act in one way in England in relation to asylum and another way in Northern Ireland in relation to the same matters? I don't think that's clear at all. The other thing I wanted to flag about withdrawal from the ECHR and Seoul Convention or sort of other procedures is There is a review procedure in the Good Friday Agreement, validation, implementation and review section, paragraph 7 of which provides that if difficulties arise which require remedial action across the range of institutions or otherwise require amendment of the British-Irish Agreement or relevant legislation, the process of review will fall to the two governments in consultation with the parties in the Assembly. So withdrawal from the ECHR is very likely, almost certain, to trigger that review procedure, which actually puts in place greater obligations than the Sewell Convention does, as it requires consultation with between the Irish and UK governments as well as the Northern Ireland Assembly parties.
That's a very important point, because I don't think that's fully understood. And you make a comparison between withdrawal from the EU. There was an Article 50 there. I'm not clear whether, you might know more than me, I can't think off the top of my head whether the Convention has a withdrawal.
There is, Article 58 allows for parties to give 6 months' notice to withdraw, but, and crucially, 58.2 states that the contracting party that withdraws will still be under the same obligations with respect to acts that were done prior to the withdrawal date. So in terms of thinking about legacy in Northern Ireland, the UK will still be obliged to comply with the ECHR in respect of acts that were done in Northern Ireland prior to its withdrawal.
As is currently occurring with regard to Russia. I mean, the Russian cases are still continuing, even though Russia has withdrawn, because the events took place prior to the denunciation.
That's right. So if withdrawal is some sort of solution to the Rwanda policy, well, think again, because...
What's a legacy?
Yeah.
Exactly. It's all been... it's prospective, only not retrospective, and that's not understood, frankly. Hannah.
Thank you very much. This is very useful. I think we're used to hearing about this in kind of hot takes and little snippets from decisions and people going, isn't that mad? So it's been very, very educational to hear these things stepped through by people who spend their life thinking them through. So that's much appreciated. I want to ask, and it's a broad question obviously, about the consequences of leaving the ECHR for the Good Friday Agreement and peace in Northern Ireland. I'll start with you, Alyson, if that's okay, because you've touched on it. What would be the impact, and specifically if you could comment on how it might affect confidence in public bodies? You've referred already to the police.
Well, ECHR is the foundation of the Belfast Good Friday Agreement. It is the thing that was supposed to guarantee future peace and guarantee civil liberties, protection of rights for everybody, so everybody could participate in and be part of this new society. And I'm old enough, I was there, I remember it, and it very much was that. And I mentioned, and I don't want to overstate this, but there was a feeling that something upon which other people had agreed, so all these other civilized nations had agreed these standards, and they could ultimately be determined outside of the country, so outside of the area where we had the conflict. That was really important. But technically, it's written into the Northern Ireland Act, it's written into the way in which the Assembly can legislate. It's been rehearsed again in the Windsor Framework. It's protected there for very good reason. So even recently, even when concerns were raised about the ECHR, etc., everyone recognised why this was so foundational and fundamental to peace in Northern Ireland and to the promises made in the Good Friday Agreement. Breach of any promise has consequences, but particularly when it's a promise that's made to secure peace, and which people buy into. I'd say 25 years of it. I don't know how it would be explained. I don't know what the problem is with being part of the convention. I don't know what harm the Human Rights Act has done. I can think of lots of things it has done to help citizens of Northern Ireland from all backgrounds and from minority groups and majority groups. In terms of government agreed to incorporate full incorporation of ECHR into Northern Ireland law, so it would have to admit that it was breaching that fundamental commitment. I don't know what it does about that, but it is an obvious breach. It also would be, in my view, a breach of the Windsor Framework, which is predicated on ECHR rights. public authorities, and Colin touched on this, and I have seen this from when the Human Rights Act was coming in. I did a lot of work advising different public authorities on how to be ready for it. And it really made a huge difference in relationships between the people they served and the public authorities themselves. It's a whole different way of thinking. But it also said to people, you have a way of holding them to account. You can go into your local court and hold them to account for things which otherwise just seem intangible. So it's hugely important. But public authorities benefited also. So police, housing officers, they all benefited. They've all got comfort from it. And it protects the police in the course of duty. It protects housing officers. And it protects everybody. So I've never been persuaded that there's anything in there that is doing us any harm. It's doing us and has done us an awful lot of good. And I don't know how you would make up the gaps and clear up the mess, frankly, if we did leave.
Thank you. Christopher, do you want to have anything to add to that?
Just one point. I agree with everything that Alyson has said, but perhaps just to add an additional wrinkle on the issue. It's also important not just that it was an international agreement, but that it's a set of standards that applies to the UK as a whole. And so, the ECHR applies through the Human Rights Act and through the devolution settlements in pretty much the same way in Wales, Scotland, England and Northern Ireland. And that's important. It's important that it's a UK standard, particularly from the point of view of arguments that have been made in the past about Northern Ireland being regarded as too separate. This is one area where these rights are regarded as UK-wide. And so we'll come on to the question about whether there's anything that stops the UK withdrawing from the ECHR with regard to Northern Ireland. But I would want to make the general point that certainly I would regard it as a failure of statesmanship for that to be the situation, that it's only Northern Ireland that's protected by the ECHR, not least because it then essentially divides Northern Ireland in rights terms from the rest of the UK. And so from the point of view of the Union, it's really quite important that the same standards apply. And if they have to apply in Northern Ireland, therefore the only way of protecting that from, if I may say, a unionist point of view, is for the whole of the UK to remain within the ECHR.
And of course, central to Belfast Good Friday Agreement was this idea of rights across the island of Ireland, and there being parity across the island of Ireland. We would be left then with Ireland still being part of the Council of Europe and signatories to the Convention, and Northern Ireland not.
I think colleagues are going to pick up on that later. Yeah. Can I ask a slightly separate question to which there mightn't be a definitive answer, or maybe there is? I appreciate that obviously the ruling yesterday will be appealed and these opinions will be tested. That and a lot of the analysis or the takes on it were that it's the fault of the Windsor framework that the Legal Migration Act isn't applying to Northern Ireland. But is it not reliant on the ECHR, and that's why? So even if Brexit and all that followed hadn't happened, it still wouldn't have been applicable because of the ECHR and the GFA and our specific protections, or am I reading that wrong?
You start.
So this is obviously a complicated question.
Yeah. Couldn't even get the question out, let alone the answer. Yeah.
No, the question is quite straightforward. The answer is what's complicated. So there were two findings essentially in the judgment yesterday. One finding was that it was contrary. Particular provisions of the Illegal Migration Act were contrary to the Windsor Framework Article 2, incorporated into UK law through Section 7A of the 2018 Act. So that was one finding. That finding was essentially based on EU law, and in particular a series of directives, the Procedures Directive, Qualifications Directive, that applies to asylum seekers. And so the predominant element in the Windsor Framework decision was EU law rather than ECHR.
Okay.
There was separate to that a decision with regard to the Human Rights Act and the ECHR, which held a very similar set of provisions to be contrary to the Human Rights Act. The major difference here is that is one of remedy. And the reason why, as it were, you can't regard the Windsor Framework Point as simply duplicating the ECHR. And the remedy that applies with regard to the Windsor Framework Point is disapplication of the Act. Yeah. So it's essentially an EU remedy, and it's a factor tame remedy.
Yes.
So that meant that the order that will be forthcoming from the court disapplies the Act. The remedy with regard to, as you know better than I, that the remedy that applies under the Human Rights Act, if primary legislation is contested, is a declaration of incompatibility, which does nothing to the status of the Act and does nothing with regard to the particular individuals who are seeking a remedy. So, with regard to two different elements, then it's important to distinguish the two elements of the finding.
So if we hadn't had the framework and all of the outworking of Brexit, the people subject to the bill would have had recourse under the Human Rights Act and the Good Friday Agreement and the non-diminution, but there wouldn't have been such a clear outcome and ruling. Is that what you're telling me?
The law would have continued to apply.
The EU law would have continued to apply.
Yeah, they may have had a remedy. So, by a declaration of incompatibility doesn't force anybody to do anything. Yeah. Government would knowingly be acting in breach of the European Convention if you just look at that part of it. And ECHR is and EU law are so meshed together, it's hard sometimes to extract them from each other. They're part and parcel of the same thing. And certainly all the ECHR rights, we take the view, are protected by Windsor Framework, Article 2. So it's, it really is, the two things really do sit together. But as Chris says, it's very much the remedy, so it's effective remedy when you use the Windsor Framework. It's a much less effective remedy when it's a declaration of incompatibility. But that recognises just how important it is to Northern Ireland that these rights are not diminished, that was knowingly given. Government did implement that restriction on itself, that it could be disapplied.
It also really illustrates the difference between the effective EU law and the role of the court-led Strasbourg law in England, Wales, Scotland and Northern Ireland. They have an entirely different effect, and very often the two are misunderstood, sometimes deliberately, it seems to me.
It's recognising expressly parliamentary sovereignty. So it can be declared incompatible, but Parliament's allowed to continue.
Exactly, and the margin of appreciation, all these things are just not understood when it comes to talking about the applicability of case law from Strasbourg in the domestic law of England and Wales, Scotland and Northern Ireland. Yeah, Claire.
Thank you. Stephanie or Colin, had you anything you wanted to add?
Yeah, I just wanted to come back to one point around the Good Friday Agreement and the obligation for complete incorporation into Northern Ireland law of the European Convention. I just wanted to address head-on, there's an argument that's been put forward predominantly by Professor Eakins and John Larkin KC that obligation is discharged fully by the enactment of Section 6 and 24 of the Northern Ireland Act. So just to put on the record that I don't think that that's correct. As we've already previously discussed, Section 6 and 24 are limited to what the Assembly does and what Northern Ireland ministers and departments do, and therefore doesn't cover all of the possible breaches of the Convention within the jurisdiction of Northern Ireland. There's public bodies that aren't departments, for example, hospitals, as we've discussed, reserved and accepted matters occurring within the jurisdiction of Northern Ireland, and potentially, albeit some limited horizontal effect of ECHR rights as well. In addition, complete incorporation of the Convention also requires the right of individual petition to Strasbourg under Article 34, and that has jurisdiction over all matters concerning the interpretation of the Convention. And individuals can only bring cases against contracting parties. Now, if the UK is no longer a party to the Convention, then there is no way for individuals within Northern Ireland to bring matters before the Strasbourg court. And therefore, it doesn't make sense to say that that obligation under the Good Friday Agreement is satisfied purely by the Northern Ireland Act provisions. Thank you.
We all agree.
Yeah.
I think, yeah.
Thank you, Chair.
Ian Farry.
Thank you, Chair, and good morning to all of our witnesses. I was going to ask you about the scenario, if it was possible, for the institutions of the Good Friday Agreement to continue if the UK decoupled from the Convention. I think you've more or less covered that in multiple ways. But could it turn very specifically to the issues around confidence in public institutions and how important the human rights framework is for those? There may well be many in this regard, but I want to focus perhaps on two in particular, which is, first of all, the policing and the criminal justice system. And as you all know, we had the patent reform and also the criminal justice reform in the late 90s, early 2000s in that respect. So just ask each of you to talk about how absolutely intrinsic that human rights foundation is for policing and criminal justice in Northern Ireland. And in doing so, maybe just outline how Northern Ireland is qualitatively different from other jurisdictions in that regard. Perhaps, Alyson?
Yeah. I spent 9 years witnessing the difference it made to policing and criminal justice in Northern Ireland, and how the PSNI's reputation, confidence, legitimacy increased and increased, despite some, should we say, bumps in the road when things didn't go exactly to plan.
Still happening.
But because they had set out this framework and they were doing their best to comply with it, and also admitting when they, sometimes, most of the time, when they made mistakes. So people really did support and have confidence in and trust generally PSNI. Anytime they put up an argument against human rights, you could see confidence in the PSNI itself directly going down. And police officers would tell me that that played out on the streets as well. So it's not just something that the senior team discussed in a classroom. They actually saw it in maintaining public order on the streets, that as soon as there was an infringement of human rights and the public started talking about it, they had much more difficulty keeping the peace on the streets. Every single chief constable has said something to the effect of human rights have made our job easier. So having this very structured approach to human rights has made it easier. Hugh Ward famously went back to GB and said that GB really needed to look at the model of policing in Northern Ireland, and specifically the human rights approach, because it had turned protests which were policed by armed response units and took place over 3 days and had burning cars, to one where 2 police officers in shirt sleeves walked down the road and the thing went off peacefully. And he said that was entirely because it was a human rights approach. That's a very direct example of it. I saw, as I say, I saw at close hand the difference it made. And police officers do need to keep being reminded of how it protects them too, and I think that's sometimes where we fail. But it covers things like equipment, what equipment they're sent out in the streets, rest periods, all of that. So it covers their rights too. But I think really interestingly, I did a trip to Ukraine in June as part of a capacity building assessment, and I went all around the country. And they are desperately trying to build their human rights network, particularly in terms of policing, even during time of war. And they wanted to learn from us how we did it, because they could see the real value in it, the operational value of it. And I can't stress that highly enough. It's not just a nice thing to talk about, something you hope for when there's lots of money and time, but it operationally makes the job easier. I'm not sure I covered all of your question, did I?
Stephanie?
One small incident and a general point. The small incident is, I'm not sure whether members of the committee have seen Blue Lights, which is...
through it last week.
Exactly. For those of you who have not seen Blue Lights, it's basically a fictionalised account of PSNI.
Also sort of a master's in Northern Ireland as well. You can take in 6 hours.
Compared to reality, some people say.
Sure. But those of you who have seen the first episode of the first series may remember that there's an incident being called in, and the person on the other side of the communication says, "Is it an Article 2 issue?" Yeah. Right, and no explanation. And it was assumed that every single person knew what an Article 2 issue was, right? I was subsequently talking to some of the PSNI officers during the festivities at Queen's, and they were uniformly enthused by PSNI, by the Blue Lights programme, because it so accurately reflected. Yeah. And in this context, it's a good example of the embeddedness of the Human Rights Act in everyday policing. So that's the sort of the spot.
What's the supplementary would be? Is it an Article 2 ECHR, Article 2 Windsor Framework?
Well, Chair, I think...
I'm going to need a third series here.
Yes, we're moving it on.
As Ms Hannah says, I think that's the next series. I think it's Article 2 ECHR. The more serious point is that, and Alyson has said this as well, the ECHR has a constitutional role in Northern Ireland in a way that I'm not sure it does in the rest of the United Kingdom. Yeah. Because it's embedded in the understanding that in order to create a society and a community of trust, you need common rules in order distrust to be overcome. And everyone in this room knows that the degree of distrust in the institutions in Northern Ireland from both communities was at an extraordinarily high level. We have to address that, and one of the ways of addressing it is to have these kinds of institutions that are common to the communities, where both communities benefit, and getting rid of those is exactly the wrong way to go.
Yes. Can I just, before we bring Stephanie, just come back to the point you made earlier on around extradition, and I won't offend you by saying you're probably the slightly older member of the panel, my vintage as well. I remember back in the 1980s, anecdotal, it seemed almost impossible at times to extradite terrorist suspects from south into north. Notwithstanding the wider UK-EU relationship around extradition and criminal justice cooperation, would there be a genuine real threat to managing terrorism on the island if we ended up with Northern Ireland out of the convention?
I think the answer must be yes, not least because under EU law, it's not just the Republic of Ireland, but all EU states are increasingly operationalising the European arrest warrant and equivalent under the general guidance of ECHR rules. And Alyson's point that it's very difficult now to tell the difference between the intersections of the ECHR and EU law applies in this context. So the extradition to non-ECHR states it clearly engages a different level of difficulty than extradition to an ECHR state.
We talk at one end of the spectrum about dealing with terrorism, which is of vital importance for life. Another end of the spectrum in terms of life issues is things like around family law, which presumably would also be impacted if it was a issue.
Before Stephanie says something, can I just add in relation to practical experience as well? I know this committee has heard from John Boucher, who headed up the Operation Canova. Everyone talks about the Operation Canova investigations. The first thing he did was sit down and get advice on a human rights-based approach to those investigations. And he has said, and I know he said it to this committee, that a human rights-based approach to those investigations enabled him to recover evidence that nobody had previously, and enabled him to engage with victims who didn't trust the police, hadn't spoken to a police officer in years. I saw that as well up close, and it was real. It was a real human rights approach. It wasn't just window dressing. And he also said in the course of his interim report, essentially, that if a human rights-based approach had been taken at the time, a lot of those murders probably would not have happened, and that a failure to comply with human rights led to more deaths than it needed to. So I would just add that as well. But I know Stephanie, I'm sure, has...
To be honest, I don't think I've got anything to add. Given
Alyson's...
Given Alyson's experience, I think she's covered everything.
Colin, you want to pop?
I could just highlight the growth and appreciation for the role of the European Court of Human Rights in developing positive obligations on the police and public authorities to prevent human rights abuses. This is particularly important in the area of addressing violence against women. And people maybe recall that the UK recently ratified the Istanbul Convention on Violence Against Women. And one point that's not appreciated as much is that the Council of Europe, in addition to the European Convention on Human Rights, has a whole panoply of other conventions there to protect rights in a number of areas. If we were no longer to have ratified the ECHR, we would leave the Council of Europe, and therefore that full panoply of conventions we would no longer be members of. Yeah.
Or the whole thing. Thank you very much. Back to you, Chair.
Thank you. Colin O'Connell.
Thank you. Just a few questions. I suppose the first one is really around to what extent do the statutory functions of the Northern Ireland Human Rights Commission depend on the UK's membership of the ECHR, and how would the Commission interpret and define human rights if the Convention rights were no longer really incorporated into domestic law? I'm happy for whoever feels they can take that.
Leave that one to Alyson.
I might pass this one to Colin as well. He's got all the stats on this. In brief, it wouldn't remove our function, but it would make our work really difficult, make our job very difficult, because we are set up to monitor compliance with ECHR and Human Rights Act. It says human rights in the Northern Ireland Act. It doesn't say ECHR, but it does go on to say that is at least ECHR, and it was contemplated in Belfast Good Friday Agreement that we would have at least ECHR plus, and that was why they talked about a Bill of Rights for Northern Ireland. So I don't know what we'd be working with. We wouldn't really have the tools to continue to do our job properly, and we'd be drawing on maybe even unincorporated treaties rather than ECHR and the Human Rights Act, which we're all familiar with, public bodies are familiar with it, everyone knows how it works, and it's worked pretty well, despite, I know, there are some remaining concerns people may have. But it would make our job very difficult. We wouldn't be abolished as a result immediately, but I don't know what we'd be measuring against. Do you want to add to that, Colin?
To add, so the Commission is one of the UK's A-status national human rights institutions. Part of the characteristics that we have to have is a broad mandate to protect and promote human rights in our jurisdiction. And if the UK was no longer party to the main regional human rights instrument, the European Convention on Human Rights, it's difficult to see how we would still be considered to be a national human rights institution in those circumstances. And we would inevitably draw a lot more on the international human rights framework set up by at the UN level. So you would have the UN Committee on the Rights of Persons with Disabilities, UN Human Rights Committee, and those various other treaty bodies that haven't been incorporated into UK law, but do have a body of jurisprudence here that we can draw on. And I would say that their jurisprudence tends to go a lot further than the European Court of Human Rights. European Court of Human Rights jurisprudence looks incredibly measured in comparison with either comparative regional courts or with some of the international treaty bodies.
Okay, thank you. Just, I suppose, my belief is that there shouldn't be any human rights border within the UK, and sort of any reform should be done on a UK-wide basis, whether that's the human rights or the ECHR. Would that be your take on it? It's important that it's done on a UK-wide basis, so it doesn't leave Northern Ireland out on a limb with that.
Well, if anything, we've got the best deal, because the Northern Ireland Human Rights Commission was set up first. It was the first Human Rights Commission. We have more powers than some of our counterparts. We have at least as much as the UK, but we have a little bit more. So we're not disadvantaged according to any other parts of the UK. If your question is there a distinction simply because there are 3 Human Rights Commissions for the UK, I would say no. So Scotland, England, Wales and Northern Ireland all have their own issues, they all have their own laws as well, and you need a Human Rights Commission, I think, in place which understands the circumstances of its own place, because otherwise I think we would be then subsumed by a Human Rights Commission which only really has experience of England and Wales. Yeah. That may be something, I know Stephanie's looked at issues like the human rights institutions, but I think Professor McCrudden might have something as well.
So I made it clear earlier on that I think it's highly desirable for the UK as a whole to have these standards. The way that you posed the question was an interesting way of posing it. And so my reaction would be I would like there to be a UK standard, provided the UK standard is the ECHR, but I would not go for a UK standard that meant that the ECHR did not apply in Northern Ireland.
Okay, that's helpful. Stephanie, did you want to say anything?
No, I mean, I agree with what Chris has said.
And then just in relation to sort of protocol Windsor framework, what assessment have you made to the extent to which protocol stroke Windsor framework, both in terms of Annex 2 and Article 2, impacts the rights of citizens in Northern Ireland compared to their counterparts in GB, and I'm thinking particularly in areas like trade, input into lawmaking, democratic deficit, etc.?
So it's a very broad question. Perhaps I'll restrict myself initially to the question of the impact on human rights and equality. Basically what Article 2 does is to prevent the diminution of rights that are protected in the Good Friday Agreement where they've been underpinned in the past by EU law. So that's the objective. From that point of view, this is a standard, a requirement that does not apply in the rest of the United Kingdom. And so from that point of view, to the extent that the protections that were previously enjoyed under EU law have been done away with in the rest of the United Kingdom, Northern Ireland is in a different position. And that's clear. It's clear from the judgment yesterday, if ever there was any doubt on it. Now, of course, we do not know what, if anything, the Court of Appeal or the Supreme Court may do with those judgments, but as we sit at the moment, it's clear that Northern Ireland has human rights protections under Article 2 that do not apply elsewhere. The question then, several questions arise from that. One is, of course, why we have those protections, and I don't mean politically, but legally, and the reason is because of Section 7A of the 2018 Act, which was the Withdrawal Act. So this was an exercise of UK parliamentary sovereignty, which essentially required these protections to be put in place in Northern Ireland. So, the simplistic argument that it's in some way limiting parliamentary sovereignty clearly is not correct. It does have the following really important implication. To the extent that the Windsor Framework, Article 2, protects indirectly ECHR rights, that would mean that it has very considerable implications for arguments about the UK withdrawing from the ECHR. In much the same way as the argument played out yesterday with regard to the Illegal Migration Act. The implication of that is that, one of the questions that's sort of hovering here is, could Parliament withdraw from the ECHR, assuming that Parliament has to give approval? And the answer is, to the extent that the Windsor Framework restricts that, the only way of doing it is to repeal Section 7A of the Withdrawal Act. The implication of that, of course, is that that's like lighting a blue touch paper and retiring with regard to relations between the UK and the EU. So in other words, there's a direct implication here of withdrawal from the ECHR in terms of relations with the EU, because in order to do that, you would have to essentially destroy one of the main mechanisms by which the rights and guarantees in trade as well as in human rights are guaranteed under the Windsor Framework. So to the extent that you want to preserve good relations with the EU, this is clearly not the way to go.
Anyone else?
Just in response to your former question on human rights protections throughout the UK, the Belfast Good Friday Agreement did contain proposals for a Bill of Rights for Northern Ireland that our Commission was statutory mandated to provide advice upon, which we did. So our mandate there was to look at rights supplementary to what is provided in the European Convention on Human Rights. Leading on from Chris's point, that the European Convention on Human Rights and the protections of the European Court should be the foundation stone upon which we build additional protections. A Bill of Rights for Northern Ireland obviously hasn't progressed, but those additional rights protections that Northern Ireland has been provided with are, I think, a reflection of the importance of rights to peace in Northern Ireland and to the confidence in our public institutions.
I failed to answer part of your question, my apologies, and that relates to the trade question. One of the links between the human rights issues we're talking about today and the trade question arises because of the Trade and Cooperation Agreement. You will know that Part 3 of the Trade and Cooperation Agreement, which basically sets the standards for criminal justice cooperation between the EU and Britain and the UK, requires essentially the UK to be a member of the ECHR. And so the Trade and Cooperation Agreement, therefore, would be, at least Part 3 of it, would be under a very severe strain if the UK withdrew from the ECHR because of its implications for the Trade and Cooperation Agreement.
Okay, thank you. And just, sorry, just one very final question, and it's you touched on it. I think Stephanie touched on it earlier around a small minority of cases in which the Supreme Court has actually departed from European Court of Human Rights case law. Is that an indication that there needs to be greater dialogue between domestic courts and Strasbourg? Is that needed? Is there greater dialogue needed?
I'm not sure. I think there already is good judicial dialogue between the two, and there are, as you discussed earlier, lots of instances of the UK courts essentially speaking first and then Strasbourg following what the UK courts have said. And as Sir Rob Buckland, the chair, pointed out earlier, we have an incredibly low number of judgments against the UK in Strasbourg. In 2022, the UK received 0.002% of the total ECTHR judgments finding a violation of the convention. So I think that indicates that there is already a really good dialogue between the two courts and a good appreciation of what the convention means for the UK by domestic courts within the UK.
If I could make one additional point, just remind me of something I wanted to say. The UK's record in front of the Strasbourg Court has improved considerably since the ECHR was incorporated by the Human Rights Act. So it actually wins more and more and more cases every year since the Human Rights Act was incorporated. So in that sense, it has protected government as well from being taken to Strasbourg.
Thank you very much. Ellie Tolhurst.
Thank you, everyone, and it's been. I've really enjoyed your evidence so far. So thank you. We touched on it very briefly, but to what extent could a Northern Ireland Bill of Rights provide for rights that reflect the particular circumstances of Northern Ireland if the ECHR could no longer be incorporated into UK law? Alyson, if you got any comments?
Well, it could, I suppose, simply duplicate the ECHR and then add bits on to reflect the circumstances of Northern Ireland, but you would lose all of that international standing. You would lose access to the court in Strasbourg. So the Bill of Rights for Northern Ireland is something that should be additional to rather than instead of, I think. Do you want to? Yeah, Colin was actually there when we gave advice in relation to the Bill of Rights, so he might be able to tell you what their thinking at the time was.
So our advice on the Bill of Rights was always intended to be supplementary to the European Convention on Human Rights, and I think we would have to completely refresh our advice. The main concern with that for us, I think, would be the loss of the jurisprudence that the European Court of Human Rights has developed over 70 years of hearing cases and delivering judgments, and how that has meant that the rights that are protected within there and their application to new and emerging issues, increased data usage in criminal justice, moves towards positive obligations, and the other positive developments that there has been in that jurisprudence. It's difficult to envisage how large a Bill of Rights would be if you were trying to capture all of those protections and the application of those rights. Whilst I don't think we would be envisaging a great additional range of rights to be protected, the European Court in its jurisprudence has looked at how those rights are protected in specific circumstances and what rights protection means in practice. I think it would be very hard to start with a blank page and try and develop a new instrument. It would effectively be doing away with 70 years of legal history and reasoned judgments. It would be a very tough, it would be a hard week in the office to make a start on developing that, I think.
The Good Friday Agreement expressly envisages that the starting point is the ECHR. It refers to the Bill of Rights as being supplemental to the ECHR and says taken together with the ECHR. So it seems illogical to withdraw from the ECHR and then try and have a Northern Ireland Bill of Rights. And it also goes back to Chris's point about having a UK-wide rights protection. If you did have a bill which was sort of the ECHR without the UK being a party to the ECHR, plus the additional to reflect the specific circumstances of Northern Ireland, you then lose this UK-wide rights protection that you currently have.
Well, and just a footnote on that, and of course, were the Assembly to try to do that, in other words, were the Bill of Rights to be passed through the Assembly, it would be restricted because of the Scottish decision in the Supreme Court to legislating only in devolved areas. Whereas, of course, you know, in many respects, the ECHR has been as much used to protect rights with regard to activities of the UK government and Parliament. So that's the first point. The second point is, if I could add perhaps a little political point here, not a party political point. The negotiations over the Northern Ireland Bill of Rights have been at a snail's pace and have been up and down and up and down. The most recent was basically after 2020 in the New Decade, New Approach context. And what happened there was essentially that all of the parties at one point agreed in principle perhaps to go ahead with a Bill of Rights, very much in principle. The DUP then subsequently withdrew its in principle agreement, my understanding, and that left 5 parties essentially proceeding to a report an in principle agreement. All of that took place in the context of it being supplemental to the ECHR. So the political point is simply this: it would mean starting all of that from scratch. And so any degree of progress, minimal though it has been, in terms of reaching agreement on a supplemental Bill of Rights, it now goes up in smoke, to put it technically. Yeah. And that would mean a significant retreat from the existing politics of the situation, difficult though that is. And so the question would then be, well, would all of the parties agree to the ECHR, even in the devolved areas? And that also would be up in the air.
Yeah. Okay.
Thank you very much.
Thank you very much.
Hannah.
Thank you very much. Again, we've touched on this, but I just wanted to ask what impact withdrawal from the ECHR would have on cross-border collaboration and the protection of human rights on an island-wide basis, including the work of the joint committee. And Alyson, if I could come to you first on that.
Well, we've been working quite closely with the Irish Human Rights and Equality Commission to ensure there isn't divergence of rights on the island of Ireland. And at the minute we have something to work with on that, because we're both subject to the ECHR. We both have our respective human rights acts incorporating directly. Chris, I think, has made the point already, and maybe want to explore Chris's point a little bit further. But in terms of just how we would work as commissions, we wouldn't. We would suddenly be torn apart. And say Belfast Good Friday Agreement was predicated on the fact that the rights would be equal across the island. And at the time, it was the Irish government who were lagging behind, actually, and they agreed to increase rights protections in Ireland. I think it's probably fair to say that they've now jumped ahead in terms of rights standards. But I think if Chris, if you want to expand on your technical point earlier.
Well, so maybe the way to take the technical point is that not only is there agreement between the UK and the Republic of Ireland under the Good Friday Agreement, and therefore, to the extent that the Good Friday Agreement is underpinned by the ECHR, that leads therefore to destabilising aspects of and imbalancing parts of that agreement. So there's that issue, and that relates to Alyson's point about cooperation at the human rights level. But there's a broader point, I think, which is that it bears repeating that the Republic of Ireland is an EU state. And as an EU state, it has obligations under EU law which are pretty significantly underpinned by the ECHR requirements. So what we saw in the context of, for example, the recent debate over migration, you saw that there was a decision of the High Court in Dublin, basically saying that there were problems under Irish law in returning people from the Republic to the UK. And that was done under EU law. But of course, the EU law, as Alyson has made clear, is underpinned by ECHR law. And so all of that mechanism becomes a lot more complicated, because basically the reason why the Irish High Court found as they did was that there had to be protections in Irish law if you were going to send people into countries that did not have adequate human rights protections. And so, to be quite direct and up to date on these kinds of questions, that dispute is a classic instance in microcosm of the kinds of problems that would multiply where the UK should withdraw from the ECHR.
In terms of cross-border investigations, I think was one of the things which I neglected to address. There is a very significant impact that will be felt, and that's in relation to, at the minute we have two countries that are both subject to ECHR. What that means in terms of investigations is both have Article 2 investigatory duties, but to help each other. So it assists UK police, PSNI, to get information off of Garda, and vice versa. So there's an obligation on both to ensure that Article 2 is complied with on the island of Ireland, especially where you have cross-border movement in relation to murders. That would be lost entirely. And there is, in terms of data sharing across the border, that is going to be affected considerably if we can no longer say that we comply with ECHR, including data protection and data adequacy agreements. So, I mean, it is going to have a significant impact on that, on policing operational ability.
And it brings us back to the point about the Trade and Cooperation Agreement. I mean, I'm not sure that everyone fully understands. I'm sure this committee is, and certainly the Justice Committee that reported to the Secretary of State is fully aware of it. That the Trade and Cooperation Agreement, Part 3 of it, is not a technical cooperation agreement with regard only to trade. I mean, it covers areas in terms of access and sharing intelligence, fingerprinting access, DNA, criminal records, extradition, mutual legal assistance. All of that is covered by the Trade and Cooperation Agreement. If that part goes because the UK withdraws from the ECHR, Part 3 being dependent on ECHR membership, then all of that is threatened. Thank you.
Thanks, Chair.
Well, thank you. Can I go back to the Article 2 Windsor Framework question? Obviously, we've seen it in action only yesterday. You've got this rather interesting distinction between the application of EU law disapplying domestic legislation and the ECHR application merely making it a declaration of incompatibility. Does that indicate some sort of uncomfortable hierarchy here?
Certainly a hierarchy. I'm not sure how uncomfortable it is.
It is simply the wording of the Act.
Yeah.
So it says expressly disapplication. So it was thought through. It was very deliberately chosen, knowing that with ECHR it is declaration of incompatibility. Everyone understands what that means. Disapplication was chosen very specifically, and I think it was chosen because it was the only means of ensuring that Windsor Framework Article 2 would actually be protected and the rights therein would be protected in practice.
Yes.
I mean, what?
And it's also
sorry.
it's also it's not that unusual in Northern Ireland because the Legislative Assembly can't legislate contrary to, and that is disapplied. There's no force.
I mean, there's a really, really important constitutional point here, which is that the court recognised yesterday, as it has in previous cases, that Section 7A, I keep on coming back to it, is the equivalent of Section 2 of the European Communities Act 1972.
Yes.
And therefore, if we carry through the logic of that therefore it has constitutional status. And therefore, when we're enforcing essentially EU law, all the EU remedies come into play, just as they would under Section 2 of the European Communities Act, hence my reference to factor time. And so the reason I said, sorry, rather flippantly, my apologies, I'm not sure it's an uncomfortable hierarchy, is we're talking chalk and cheese here. The chalk is the ECHR with its own remedies, and the UK Parliament has decided declaration of incompatibility in that context. But equally, the UK Parliament has decided under Section 7A it's European Union remedies, and the court has recognised that. And so it's a, if I may say, it's a false equivalence, which is an understandable equivalence, given that they're both talking about rights and overlapping rights. And so from that point of view, it may look awkward, but the logic is impeccable.
Yes. And I suppose it begs the next question, and I think there's been some discussion, whether Article 2 of Windsor effectively prevents withdrawal from the ECHR. What do you make of that argument?
Well, that's the $64,000 question, really. So the way I'd put it, I'm sure Alyson will have views on this, and Stephanie, but the way I would put it, I think, is that to the extent that the Good Friday Agreement requires ECHR, and paragraph 2 of the relevant section of the agreement specifically refers, and Alyson has referred to it previously, to remedies having to be provided domestically or the ECHR. To the extent, therefore, that the Good Friday Agreement is underpinned by the ECHR, the logic of the decisions up to now has been that there would be considerable difficulty in withdrawing, provided, because of the Windsor Framework, provided you keep Section 7A.
Yes.
Obviously, parliamentary sovereignty is clear, which is the Parliament can repeal Section 7A. And if it does that, then it has political and legal implications with regard to all of the other relations with the EU. But legally, in terms of domestic law, Parliament can repeal Section 7A. As long as it does not do that, and as long as the courts keep on in terms of the trajectory that they're currently taking, then it would create considerable difficulties in withdrawal.
And I suppose the wider question as we come to the end of this fascinating session is the general impact that ECHR withdrawal would have on post-Brexit relations, EU-UK relations, and the particular implications for Northern Ireland. I mean, I think I know in my mind what the answer might be, but I'd like to hear from the panel as to its assessment of the impact of such a withdrawal on those future relations.
I'm going to be very general, if I may. I'll let others be more technical if they wish. it would be such an obvious breach of promise, which was translated into an international treaty, and it would be a reneging on commitments made to the people of Northern Ireland as well, and to the sacrifices that they made for the Belfast Good Friday Agreement. A lot of people gave up an awful lot. And they were rewarded, if I can put it that way, by this promise that they would always be protected by these standards that were greater and not subject to political will or change of government. It would be very difficult to explain to them then why that no longer is the case, why that has to be got rid of, especially since so recently, when Northern Ireland, contrary to its expressed will, was taken out of the EU. It was told it would be protected and continue to be protected, and the ECHR and membership of the Council of Europe would be part of that protection. So we all know how dangerous it is to breach promises, and to do it without reason, without justification and any sort of real rationale, would be very troubling, I think. I think it would permit people to say, well, what on earth was all that about? As a Human Rights Commission, and we're A status, and that's more than just a sort of badge of honour. That gives us speaking rights in Europe and at the global stage. I would no longer be allowed to do that. I wouldn't have any speaking rights, so Northern Ireland would not be represented on a global stage. And I know, and I'm just back from one meeting, I know that the threats to leave the Council of Europe and remove itself from the Convention is talked about across Europe and across the world. And it's not doing the UK any favours. And lots of people, sometimes even more people than I see at home, are asking me about exactly the question you asked. What impact does that have on the Good Friday Agreement? Because we will not be happy. Because a lot of people watched what happened. So it has to, in my view, it has to be protected. But also practically, what are the police going to do if you suddenly tell them all the things they've learned and trained and put into operation, they actually no longer have to comply with them?
I think, as we've heard from Chris, the technical details, the ECHR underpins much of the post-Brexit arrangements with the EU, and withdrawing from that risks disapplying parts of them, opening up renegotiations with the EU after years of already having had that. And I think the people of Northern Ireland, felt a little bit like a political football during the Brexit negotiations, and to put them back in that position after many years of those already long negotiations would seem incredibly detrimental. And as Alyson has already very well expressed, obviously the ECHR is fundamental to the peace process, to the Good Friday Agreement. It's not an add-on to that, it's woven into the Good Friday Agreement and the peace process and political institutions in Northern Ireland.
My response is that as an academic, I like to see argument, and I've yet to see any sustained, credible argument that addresses the kinds of issues that have been discussed today by those who are advocating withdrawal. Meaning, and you mentioned him specifically earlier on, so I'll, if I may mention him also, Lord Sumption's argument, powerful though it may be in other respects, we can discuss that, does not address in any way the difficulties that would be occasioned with regard to the EU, nor with regard to Northern Ireland. Completely ignored.
That's right.
And that seems perhaps surprising, but also regrettable. So my general point is we can identify pretty easily all of the detrimental effects in withdrawal for the people of Northern Ireland. And I've yet to identify any argument in favour of withdrawal from the point of view of Northern Ireland.
And would you agree with me? I mean, I've long been on the record as being somebody who's very much of the fundamental human rights camp. I don't believe in socio-economic rights, and I am mistrustful of a court or institution that seeks through mission creep to create those rights without the express will of the member states. In other words, they would have to be prescribed in a revised convention. would you agree with me that that's a very different set of arguments from ones about withdrawal, and that surely the arguments that people like me can have are ones that we can have within the Council and within the Convention, rather than ones that would necessitate walking out the door?
So obviously the question of socioeconomic rights is a difficult one, and gives rise to considerable debates. In practice, most of the socioeconomic rights, as it were, that are now on the agenda are now being dealt with or considered under EU law.
Well, that's right. And the Charter of Fundamental Rights is a very different creature from the Convention. It's a much more wide-ranging and prescriptive set of rights that gives people like me the collywobbles.
I won't comment on your colleague, whatever it was. Just say this. The reason why I'm hesitating in fully agreeing with you, Chair, is that we come back, I'm afraid, to Article 2 of the Windsor Framework, and in that context, the Good Friday Agreement refers to civil rights. Two judgments now in the Dillon case in the High Court, and yesterday's decision in the IMA case specifically referred to the role of the Charter of Fundamental Rights as one of the underpinnings of civil rights in the Good Friday Agreement. And both judges referred specifically to an interpretation of civil rights as including socioeconomic rights. So we can discuss that, but I do want to put it on the record that the socioeconomic rights aspect of it may well be coming through with regard to the application of the Charter, which remains in force in many respects in Northern Ireland. And a good example of that is a recent decision from the European Court of Justice in the CG case, which was a case originally from Northern Ireland prior to Brexit, where basically a minimum standard of living was required under the Article 1 of the Charter, which protects human dignity. And so, to the extent that human dignity requires an element of socioeconomic rights, I'm sure we can agree that that's an important dimension.
It is, though it's much better to transfer it into the form of statutory duties by public bodies rather than rights. Well, that's my personal view, all right? But the point I think we can make is that that issue isn't a problem of the European Convention. It's an issue raised by the Charter, which is, of course, an EU charter. Well, Colin, did you want to come in?
Just in returning to your original question on the impact of withdrawal for Northern Ireland, the EU has issued two data adequacy decisions, one under GDPR and one in relation to the law enforcement directives.
Yes.
This allows data to flow freely from the European Union's members, such as Ireland, to the UK. The PSNI have highlighted the fundamental importance of that to their effective operations in tackling cross-border crime. And if the data adequacy decision specifically references the fact that the UK is subject to the jurisdiction of the European Court of Human Rights and has ratified the ECHR. So if we were no longer to have ratified the ECHR and no longer be in the jurisdiction of the European Court, that would no longer be the case, and I would imagine that adequacy decision would be reviewed immediately. I know that the House of Lords European Affairs Committee are currently considering data adequacy, its implications for the UK and EU relationships.
Yeah. Thank you very much. Well, can I thank all panellists for a very stimulating session. We're extremely grateful. An urgent question has been granted on the yesterday's case, so I'm sure colleagues might want to take part in that. I'll now bring proceedings to an end. Order, order.
The proceeding has ended. The proceeding has ended. The proceeding has ended. The proceeding has ended.